closed session. You may be seated. Yes, ma'am. Let's proceed.
Good morning. May it please the court. My name is Emily Carty, and I represent Mr. Joyner in this case. And this case is before you on direct appellate review. And I'd like to begin with the issue on the question of the sufficiency of the evidence of identity. And if there's time, I'd also like to address the sufficiency of the evidence on the question of force and fear in this case, because that is also a serious issue. The sole issue in this case was identity, and the only evidence of identity was the single partial latent fingerprint. And the jury here had insufficient information to evaluate the meaning of that fingerprint evidence.
And was that objected to at trial? I didn't see it in the transcript.
This is not preserved. It was not objected to. The issue of identity sort of ran throughout the case.
No, but as to the adequacy of the testimony of Mr. Foley concerning the fingerprint.
The sufficiency of the evidence and the whether or not the jury would have sufficient evidence to evaluate the meaning of the fingerprint evidence was not objected to. So this is under a substantial risk analysis. But of course, where there's insufficient evidence, there inherent in an insufficiency of the evidence under McGovern is a substantial risk of a miscarriage of justice. More specifically about what information or how the jury didn't have sufficient information to evaluate the meaning of the fingerprint evidence is that the 21 points alone do not tell us whether this is just one person who could share those 21 points, 10 people who could share those 21 points, 100 people, 1,000, or 1,000,000. So there's nothing to show that this is the only person with 21 matching points. And without that information, the jury had no way to understand.
Sorry, did Mr. Foley testify that there was no other person that could have these 21 points?
He did not say that this was a match. His testimony largely comported with the recommendation in Gambora and in fact the judge was specific and careful about limiting his testimony. But his testimony was that there were 21 points, there was no dissimilarity, there was no exclusion, which would prevent an identification. So of course, inherent in his testimony was that these are 21 points, and this fingerprint has 21 points.
So your real complaint is that Gambora is inadequate?
I think that Gambora began the conversation, and Gambora is on the right track, but I think that fingerprint evidence requires, that the jury requires more information than they were given.
What more information is out there?
The information that's out there is obviously not in the record, but the NAS report, which is referenced in the brief, does say that like DNA, the probabilities and the population statistics that are available for DNA could be available for fingerprint evidence. So fingerprint evidence like...
Does it, as in DNA, is there any, does anybody do that? I don't mean, I know it's not part of this record, I just don't know scientifically whether that is an approach that's taken with fingerprints.
I don't know that anyone... I don't know whether anyone does that or not. I would suggest that since the NAS report did report and indicate that that was possible, I would imagine that there are studies. The other piece of that is that we do know that we have vast database of fingerprint, and we have advanced statistical modeling. And so I would imagine, based on the NAS report and sort of our popular understanding of what science is out there, that this could
But
be
the record doesn't help us at all in knowing what else might have been out there or done here. Not, the effect of not having preserved this is that there was, of course, no request for, as far as I can see, a Lanigan-type hearing. There was nothing to challenge the science. There was nothing to challenge the admissibility of this type of evidence. So how are we to get our hands around what your complaint is?
Right. The record doesn't help with the kind of evidence that would have been helpful and necessary for the jury to determine guilt or innocence. But the question here is about sufficiency of the evidence and not admissibility. So even a Daubert-Lanigan hearing wouldn't get at the issue that is in this case, which is there are 21 points that were
Well,
met.
wouldn't it? I mean, isn't it a question of whether or not the expert is going to be helpful to the jury?
Yes, I mean, there is a piece of admissibility here, and certainly perhaps a Daubert-Lanigan hearing would have provided an initial sort of gatekeeping function about this evidence. But in the record that we have here, without that, there is still a problem of the sufficiency of the evidence, and I don't think that can be ignored simply because on the record there wasn't a Daubert hearing.
Go ahead.
I'm sorry. So you're saying basically it's admissible, but it cannot bear the weight of proof beyond a reasonable doubt.
That's precisely correct. Right. This was the only evidence, unlike a lot of cases where there might be fingerprints and then there would be other evidence of identity. Here, we don't have an in-court identification. We don't have an out-of-court identification. We have no other evidence to identify and to connect my client with this alleged robbery.
We have, if I'm remembering correctly, isn't there evidence, there's a description from the video?
There is a description.
And there's a description of hands, there's height, there's some other stuff.
There is other stuff, but those other factors, even alone or those other factors together, wouldn't be sufficient to prove identity beyond a reasonable doubt. The approximate height and race or skin
No, but you said there
tone-
was no other evidence. I mean, you have to look at the total, what's all there, which
There's no
includes
other-
all of those things.
Right, and those other, I'm sorry for interrupting, the other evidence, though, wouldn't have been sufficient either. They're highly generalized characteristics, height and approximate skin tone. And, I mean, when you look at the transcript, race and skin tone are highly contested here, and so there's really no consensus about that evidence.
But you have the expert here saying 21 matches, and I believe there's something about that he said I've never heard of. Well, he talked about I wouldn't say that if there was any piece that was dissimilar, I would have excluded this, right?
That's right.
And he also mentioned something about never having heard of two people having the same, right?
Right, but the claim of individualization and his testimony about the 21 points doesn't provide us with a standard to understand what the 21 points means. We don't know. There's no standard indicating that 21 points equals a match. We don't know whether 15 points would be a match or 30 points would be a match. We don't have any way of determining whether the 21 points, how that would relate to the general population, that if there are 21 points here, that excludes 200 million people. In the same way that we have that we do know for DNA analysis, and that this court has said is required for DNA analysis.
But didn't the value of all this come out on cross-examination of the fingerprint expert?
I would say no, Your Honor. It didn't come out on cross-examination, and I think there are two reasons. One, this court in Gambora, in the concurrence in Gambora, cautioned about the value of cross-examination in fingerprint, in fingerprints, because the fingerprints have this sort of special mystique, or they're deceptively alluring.
Yeah, but one of the ways to pop a needle through the balloon of that mystique is through cross-examination to explore all these possibilities, that there could be 50 matches and you've only got 21.
I think that cross-examination is a piece of that, but the cross-examination certainly can't make up for the fact that the attorney doing the cross-examination doesn't know what 21 points means, because
Well, isn't it up to the attorney doing the cross-examination to explore what he doesn't understand?
I was going to say that the expert has not presented and doesn't have any sort of standard to explain.
And did that come out in cross-examination?
It didn't come out in cross-examination, and there's the second bench conference between the attorneys and the judge. There's a discussion about the limitations of the expert's testimony. And the judge is also cautions counsel about what he should go into because there's a fear of opening the door that then will allow that expert to testify that these were a match, which was specifically cautioned in Gambora, but the judge says if you go into the NAS report, that could open the door to the expert being allowed to testify to a match. So there really wasn't.
And where was the
possibility.
fingerprint found?
I was just going to ask you, isn't that the other connection, though? I know that you say that's in question, but isn't the transcript actually more readily read to say that the fingerprint, there is a connection to the person on the videotape who was seen holding the cash register where this particular fingerprint partial was lifted? And you argue, I think this is the only thing that can distance you from that, and so my question is twofold. If we don't buy that this question from the prosecutor, here the question is, where did the suspect touch the drawer? It was answered as though the person heard, or maybe, in fact, it was said, the door. So it seemed like the front of the door handle. That's the only thing that distances the person on the videotape from the location of the if the jury doesn't believe that, if they say, okay, that person on the videotape touched the cash drawer where they lifted it, isn't that a connection? The further connection. It's not just generalized.
It's a connection to who. It's a connection to the. So to answer Justice Spina's question, the fingerprint was taken from the back
Right.
of the cash drawer.
Right.
That is a connection between perhaps the person who went into the store to do this alleged robbery, who grabbed the cash drawer and took it out. But that does not connect that act to my client, because the only evidence here that purports to do that was the content of the fingerprint, right? So you have the fingerprint on the back of the drawer, and so that says, okay, well, whoever touched that.
Well, it's more than that, because it's, I mean, we have cases where, a defendant's fingerprint appears at a scene of a crime, but it appears in a location where thousands of people touch or put their hands. Most people don't put their hands on the cash drawer.
Right, and this was a theory, this was the sort of this was the theory that was advanced at trial, that there may not have been, there's no proof that this fingerprint was placed on the cash drawer at the time of the alleged crime. But the argument here is different than that. It's not the sort of Salemi type argument. The argument here is that even if the person placed his fingerprint on the cash drawer at the time of the robbery, that fingerprint, there is insufficient evidence on this record that that fingerprint is my client's fingerprint, that there is no.
Well, it seems to me you're asking us to say that the fingerprint itself has to be connected to your client by proof beyond a reasonable doubt.
That's absolutely right, because there is no other sufficient evidence to prove identity beyond a reasonable doubt, and that, of course, is an essential element to convict someone of a crime. And so, yes, in this case, and of course, this is an unusual case because there's often other evidence of identity, but in this case, that fingerprint has to be connected to my client beyond a reasonable doubt, and it wasn't. There wasn't sufficient evidence here to connect that.
Here's my concern. It's a bigger picture. If there had been no fingerprint in this case and he had run from the gas station and somebody had a rather fleeting glance of him and then identified him from a photo spread as the robber, we probably would say that's sufficient for a jury. We generally would say the fingerprint evidence is better than the eyewitness ID. So if we do this, where does this take us?
Well, that would be a better case if there was an out-of-court identification based on a photo array and some fingerprint evidence. That would certainly be.
No, I'm referring to
No
eyewitness ID
fingerprint
alone.
That just the ID alone.
Which we have cases like that, where it's the ID alone that is all that the government has.
That is a different case. What we get now is that, a different understanding of where of where fingerprint evidence, the status of fingerprint evidence in as evidence and as sole evidence of identity. And I mean, this court did this with respect to DNA. And there has been a lot of chatter about fingerprint evidence. The NAS report presented the problems with fingerprint evidence. And so, yes, this would perhaps change the way that we see fingerprint evidence. But it's not impossible, because there are ways that this evidence could be used, such as if there were the statistics.
But what if this expert had been allowed to testify it's a match? Would that be enough, or?
That would not be enough in this case. I mean, one, I think that the court was on the right track in Gambora in cautioning that kind of match, because there actually isn't any science, or there wasn't any testimony about the scientific underpinnings of testifying that those are a match. But even the idea of individualization doesn't answer the question of whether the prints come from the same source. So if this expert had testified, yes, these are a match, that still would have been a problem, because, one, we have no standard indicating why these are a match, and we are purporting to give the jury scientific evidence when we have not explained to them.
Can I ask you, how many points does the FBI require?
There is no more requirement. The FBI doesn't have...
Used to be, what, 12?
There used to be, and I cannot recall the number anymore, but they decided not to...
What do they do? Fingerprints used every day in court. What do they do?
Well, I don't know what the FBI does, but I mean, we look at the two fingerprints and...
Sure look the same, and there are no dissimilarities? That's sort of this testimony here.
Yes, but I would encourage the court to turn to...
Let me just ask you this. What are you saying? I'm just trying to figure out what you would like the court to say. If you're going to use this 21 or whatever number you come up with, the expert testifies, that she would have to say as well that the likelihood that there would be 14 or 21 matches between the unknown and the defendants and this person is 1 in umpty million. Is that what you're saying needs to be there?
That needs to be there. And I with the understanding that, there may be some lag time between when that information, I don't know whether that information is wholly available now, but yes, that is precisely the kind of information that we need with fingerprints, because we required of DNA, and they both have this sort of...
Anyone else requiring this? Any other jurisdiction, federal or state, requiring that predicate to an expert's testimony? I
am unaware of any. Admittedly,
But
I didn't do a 50-state survey on this, but...
Does it's a 2006 NAS report on this, right?
It is.
Does it suggest that there is, that this exists somewhere?
It suggests that it's possible, and I would suggest you turn to, it's page 140 on that NAS report, and it says that that the population statistics are feasible for fingerprints, and there are certain characteristics that could be uniform enough to create these statistics for fingerprints, and so yes, it suggests that kind of information could be had, and I want to say that there also could be other safeguards in addition to the statistics, making sure that before, if we don't have these statistics, that the jury knows that this is not science.
Are you arguing that the judge impermissibly restricted the cross-examination of the expert?
No, I'm not arguing that. No, not at all. I'm arguing that actually the judge's restriction was appropriate under Commonwealth versus Gambora.
It's just that once you get there, you don't have sufficient. It makes the evidence useless.
Precisely. Yeah.
Well, counsel, your time is well over, so we'll have to leave it there.
Thank you.
Yes.
May it please the court, Carolyn Burbine for the Commonwealth. I would just like to point out, I don't have Gambora, a copy of Gambora, but I do have a note from Gambora that says there's a footnote in it in which it states that the NAS suggests the need for research in certain areas, including ridge flow and crease pattern distributions within various populations, and the discriminating value of certain types of ridge formations that, among other benefits, could lead to statistical models to give match probabilities based on population distributions of particular ridge characteristics and provide the courts with additional information to consider when evaluating the reliability of the science. So it doesn't appear that what my sister is suggesting should have been testified here is even available. But regardless, we had more than just the fingerprint evidence, as has been discussed. We had the evidence of the height, the skin color, both from the victim and from the detective's
That
observations.
have been enough on its own?
I think we probably would have needed the,
Yeah,
mean, the
6-1 in white
fingerprints.
hands, 6-1 in white hands is not really
no,
going to
we
get you
need
very
the
far.
fingerprints, but I'm saying that together, plus,
Yeah.
right, plus the evidence that from the store owner that no one is allowed to touch the cash drawers. We're not talking about the cash register, we're talking about the cash drawers, except for the employees. He said the defendant never worked at the store. He didn't know the defendant. The victim said the defendant never worked there. He had never seen him in the store before or after the robbery. So we have that link as well. So I think when you take the information from the victim and the police officer who saw the surveillance video as to height and race, the jury could look at the height, the jury could look at the skin color, and they were asked to. The defendant showed his hands, and the fingerprint evidence and the lack of access that was established for the defendant to have ever had access to touch the drawer, and the fingerprint expert's testimony, we met our burden.
But that's just the question, is if the fingerprint evidence, without some framing statistical context, is useless. I mean, the fact that there's 21 matches, what does that mean?
Well, I think that's sufficient. The jury had the pictures in front of them. It was explained to them the framework of the analysis.
Right,
They
but you
could-
can see that hypothetically, if 1 out of every 3 people match 21 things, it wouldn't.
But he did, there was testimony that the NAS asked the question of, and this is how he phrased it, how can one say an individual has the same set of fingerprints as no one else? You can't say that statement because you haven't examined every child not born yet, every person that's died. But then he went on to testify, nonetheless, no 2 individuals has ever been discovered to have identical fingerprints. Twins sometimes have the same fingerprint pattern, but not the same minutia points. And I think that the jury could use that testimony to evaluate, as well as their own visual observations of what he presented, as whether this is enough of a fingerprint, whether this is enough of.
Yeah, but I mean, it's one thing to say that no 2 individuals have the same fingerprint. It's something else to say that 21 points on this fingerprints match 21 points on the defendant's, and therefore
They're the same.
they're the same. I mean,
But he-
why can't you take a picture of one, put it on top of the other, and say, and everybody that can then look at them and say, oh yeah, it's an overlay, it's an exact overlay.
But I think what the expert is supposed to do is assist the jury, and he did. He explained his methodology, the ACEV methodology. He explained that if he found a ridge on one where there should have, and no ridge on the other, then it would be an exclusion. He explained dissimilarities. So he gave them a framework. It wasn't just in a vacuum, like I found 21 points and we should be done. And he was careful not to cross the line of not giving it as an opinion or acknowledging it's subjective. So the jury could evaluate and reject it if they chose.
I mean, the problem, of course, is that in the DNA context, somebody could say 99% of the DNA is exactly the same, and one could be a human and the other could be a chimpanzee. The fact that 99% is the same doesn't matter if it's only a 1% which distinguishes among species and and a smaller amount among individuals. So do we know enough about fingerprints to be able to get past that?
I think Gambora says that we do. It did not, even in the face of the NAS report, reject the fingerprint evidence being produced at trial. It just cautioned that you have to be careful exactly how such an opinion is posited. But I also want to say
Of course, in
DNA.
Gambora, there was at some point a recognition that the evidence in that case was pretty overwhelming. Otherwise, apart from, and the fingerprint evidence wasn't being asked to bear the weight that it's being asked to bear in a case like this.
True, but I would also say, as was noted earlier, that there isn't enough of a record here. There's no motion in limine under Bear-Lanigan. There's no objection at all to the testimony from the expert. In fact, at a bench conference, defense counsel says, hey, if he wants to say 21 points, match 21 points, that's fine with me. So we didn't cross any lines regarding Gambora. He explained his philosophy, and I just don't think I think DNA is so difficult for juries to understand, but fingerprint, it's just more common sense, more common experience. Here is the picture, here are the points, here are the points. You can look at this yourselves visually, and they were presented with giant pictures on easels.
Yeah, but
and they
how do
could
you
determine
know
it.
that it isn't one out of every 3 people that have the same, you could do the same for?
Well, again, I'd go back to the testimony that he gave as an expert, that no 2 individuals have been discovered to have identical prints,
But
not
that
even
doesn't-
twins.
But that doesn't
So
tell
it
you whether
limits-
21 minutiae points means that they have identical prints.
But it's not in a vacuum. I mean, they're also hearing testimony about access to the cash register, access to, it just, if you put it all together, I would say that we made our case.
Did the jury have the photographs of the fingerprints in evidence?
Yes, they did.
So the jury could sit there and try to find
could try
points
and-
that differed.
Yes, and he had gone through every single one. Number 1 is a delta, number 2 is a whirl, number 3 is a whatever. Every single one, he laid it out. And actually, the judge was taking notes along the way herself. So they had that ability. So,
And that's different than DNA, how?
well, I think DNA, I think just for a jury, it's just much more approachable. They've been, all of us grew up with, fingerprint evidence, part of cases. DNA is a newer science. It's just so complex.
Yes, but the jury can look at photographs of the graphs that.
Graphs, I suppose that's true, but I think it's just a more approachable science for the layman. I know it is for me, just.
Can I ask this? I mean, there are organizations of fingerprint examiners, and there are lots of government bureaus around the world that do this and have their own standards, presumably, as to when something is conclusive enough to be the basis of an opinion that it's the same person, right?
It's
Don't
not
these
on
things
the record.
exist?
I mean, I would assume.
I'm asking you generally. Don't these things exist?
I don't even know, Your Honor. I
I mean, it used to be a point in time where the FBI's view was X number of points was sufficient for an expert opinion, and the state police, maybe state lab, had a different view, a slightly different number of points, and organizations had even a different view, as long as there were no inconsistent points, obviously. We're talking about points that match and no inconsistent points. None of that exists anymore after the NAS report?
honestly have no idea, Your Honor. I haven't researched it, and I don't know what the reactions of various agencies have been as a result.
And there was no litigation, no Lanigan hearing here?
We
so
have
there
no
was
Lanigan here. We don't have a record here to
But the
really.
issue is really not admissibility. The issue is weight. So it's not. So I don't know why it would matter. I mean, it's certainly admissible. I think no one's telling me it's not admissible. I think what she's essentially claiming, as best I can tell, is that the restrictions we imposed in Gambora essentially means it can't bear the weight by itself. I mean, what do you say to that point? That if you read Gambora, the limitations that we've imposed upon the opinion, essentially the consequence of that is that it can't bear the weight by itself.
I don't think that's correct. I think that, again, where he did, we have the exhibits, we have the 21 points. I still think that the jury was presented, and the context of all that information. I still think the jury received enough information that it was helpful to them, and that they could make that determination.
Right. In the DNA field, we've said that you have to have the statistical opinion for it to make any sense at all. Why doesn't the same thing apply here? I mean, why shouldn't there be some sort of science that develops that shows that, whatever it shows, that, certain combinations of points and swirls and twirls and ethnic comparisons, there's a likelihood of, a percentage of maybe 89% that the defendant authored both fingerprints.
As I said before, I'm not sure that even exists now, and that was the problem that the NAS had with the
Until
study.
it
But
exists.
the NAS still didn't say we shouldn't be using fingerprint evidence at trials. I believe that is in Gambora. They didn't say that we should cease using them, that it's such an inexact science that it shouldn't be admissible anymore. But it suggested it could be improved, and I believe that was the footnote that I read, to give even more information to juries, but it didn't recommend throwing it out and calling it invalid altogether.
If the DNA, if the statistical information that we require in order to set a framework for DNA evidence didn't exist, but was possible to be developed, is it, I mean, did our opinions reflect a reality that that statistical information was in fact available, just wasn't admitted, or had to be developed as here, and until it was, we weren't going to allow it to be used?
In the DNA cases?
Yeah.
I'm afraid I didn't do that research, so I can't answer that question.
I take it that under Gambora, Mr. Foley could have testified that, in his opinion, there was a match, in his opinion.
Yes,
But he didn't testify to that here.
right.
Okay, he testified that, well, he testified slightly differently, that no two people, in his knowledge, had ever had the same fingerprint, and, okay.
Right,
And,
that's correct.
but it sounds, I haven't seen the record, it sounds as if he didn't because the judge wouldn't let him.
The judge kept saying to both the prosecutor and defense counsel, I don't want to tell you how to try your case. I believe that was clear, but she was saying, I read Gambora like this, but, and they had an opportunity to dispute it with her, so, and they were arguing between, the two parties were arguing between themselves, too, as to what would be appropriate. So I don't think that she at all controlled what defense counsel asked. I mean, she made suggestions, and he
No, but
decided
she
whether he would
couldn't,
take them.
but
He
but I
didn't
think the
order him
question
not
that,
to.
but Justice Cordy's question is, couldn't the prosecutor have asked, do you have an opinion, Mr. Foley, as to a reasonable degree of fingerprint certainty, that about whether the known and the unknown are from the same person?
She could have had a little, she could have asked him to present an opinion on that it's a match. I think she was being cautious because of Gambora, where it says, what does it say? It says, testimony to the fact that a latent print matches or is individualized to a known print should be presented as an opinion, not a fact, and opinions expressing absolute certainty about or infallibility of an individuation should be avoided. I think she's just being very cautious and
But all that means
saying, I
is-
have a chart with 21, we're going to just limit it to the...
But all that means is that it's my opinion that these two fingerprints were made by the same person. It doesn't mean that, and it prohibits them from making a bald statement that it's a
Right.
match.
I agree, but I think, I don't know what her motivation was, but I think she was being, holding back a little bit out of caution, even though she could have asked for that testimony according to Gambora.
If I could turn you briefly to the probation issue, I'm sure that the conviction would have been sufficient for a judge to so find, but isn't the judge her own fact finder? And with regard to a probation violation, is a conviction dispositive upon a judge? What if she had listened to that same evidence at trial and said, I come to a very different view of the evidence. I don't think there's even proof by a preponderance.
I don't know the answer. I don't know the answer to that. It's just, I suppose she could, but she can also just summarily say, I have a conviction in front of me, and that's enough. It's in her discretion whether to find a probation verification. I find it difficult to see.
But what about the...
She had an opportunity. I'm sorry, but she had an opportunity with the motion to set aside the verdict had she believed that evidence. Here she did.
But that's a different standard. She didn't say it was legally insufficient.
but-
She's not a 13th juror, but she is a fact finder with regard to the probation violation. Why should she not have allowed him to offer evidence to rebut it?
Well, because it's a criminal conviction, so, he's been convicted beyond a reasonable doubt. Why would a judge have that discretion once there's been a conviction to second guess that? There are other avenues available to the defendant for him to make that presentation, and I don't think it would be appropriate for a judge.
I thought it
you
was
would
your
say
argument that she had the discretion not to hear it.
She has discretion not to hear it. She has discretion whether or not to hear it, yes.
Right.
She can decide whether she wants to hear it or not, and that should be
Said
it.
no.
And she said no.
Been there, done that.
And it's a conviction, and she decided it, and she had reason to. Why should she hear let him get into this purported alibi and fingerprint evidence when there's a conviction beyond a reasonable doubt.
Collateral, I don't
benefits.
know. I mean, aren't there some collateral estoppel consequences of the conviction on this point?
Well, who has jurisdiction?
No,
who-
no. This is on your side of this case.
sorry.
But I mean, in other words, if the jury has found beyond a reasonable doubt that he committed this offense, so if that's the basis of the probation violation, that he's committed another offense, I don't know that there could be second guessing of that jury verdict.
Well, I don't think that there should be. The conviction stands. It hasn't been overturned, and she was the trial judge.
But I do
But
have a
that's not always
question-
the case.
But I do have a question as to the second level of the probation violation. In other words, you might find him in violation, but she wouldn't hear anything on disposition either, isn't that right?
I disagree. She allowed. She wouldn't hear this alibi or fingerprint.
But she wouldn't even,
information,
I
but
think
she
he had
did-
he wanted to talk about being addicted.
Well, it's odd because at the very beginning he mentioned drug use, but then when you got to the sentencing portion, she let him talk. She let him represent that he didn't believe the defendant had committed the criminal offense, that 8 to 12 years was a long time to serve, that overall the defendant was a good probationer. He made a 5-page argument. This is the probation revocation attorney. 5-page argument about sentencing options, and then she let the defendant speak on mitigation. And neither the attorney nor the defendant mentioned this purported drug use. And I'd also point out on the sentencing on the criminal conviction, his other attorney never mentioned this purported drug use. So I don't think it's fair to say she foreclosed it. They just didn't bring it up. Did the court have any further questions?
Thank you.
Thank you very much.